He's here. Yep.
I'm here, but I'm not hearing anyone in the room.
Good morning. We can hear you. Can you hear us?
Good. All right.
Okay.
Now I do. Thank you very much.
All right. Can you, Carl? Yes, I know. Carl, can you, well, hold on. All right. Good morning, everybody. Time is now 8:31 a.m. We are back on the record. We are in docket 2022.07.07A. We are on the third day of our hearing. Today is Thursday, April 13th. Where we had left off last evening was that we had Dr. Dismukes on the stand. Commissioners had completed their questioning. We were going to cross, but then we had a request for a witness accommodation, which we granted by MEIC. Ms. Harbine, just for clarification, are you putting on your case in chief right now, or just single witness, or?
Mr. President, Commissioners, my intention is to offer a brief opening statement, and then our second witness is slated to appear later in the hearing.
Okay. Does anybody have an objection to that? Make some sense? Okay. Ms. Harbine, you have the floor.
Thank you. Good morning, Mr. President, Commissioners. Jenny Harbine on behalf of the Montana Environmental Information Center. I just want to briefly, before we present our first witness here, sketch out some overall things as MEIC sees them in this case. And the most important thing I want to communicate is that this general rate case is complicated. And there's no easy fix to the issues that are before you in this case. I think Mr. McGraw said it, but what I believe is clear to everyone in this room is that this is a utility in some distress. And I just want to set the backdrop for this case and the events leading up to it. In 2020, Northwestern Energy said they needed pre-approval of their planned expansion of their Colstrip Unit 4 ownership, claiming that the expansion was critical from a capacity perspective, but they abandoned that request before we got to a hearing. In 2021, Northwestern sought pre-approval for the Yellowstone gas plant, but abandoned that proceeding too, electing instead to build the plant without the commission's review, even after interveners, including the large customer group, said they thought the plant was likely not in the public interest. In the last decade, the commission has twice disapproved significant company expenses associated with major outages at the Colstrip plant, finding that Northwestern had mismanaged or not exercised prudence in its management related to those outages. The commission leveled significant critiques of the company's last resource planning process, which as of today haven't been fully addressed. And this is a second consecutive rate case where the company requested a revenue requirement and ROE well in excess of what they apparently need and have settled for. And in this case, the company lurched ahead with a reliability rider proposal that was novel in theory and expansive in scope without even first testing the waters with regulators and stakeholders to gauge its approvability. And now Northwestern abandons that proposal too, because apparently it's not so essential after all. The company's actions have put Montana ratepayers at risk, and their failure to plan for the future will only compound that risk. This is a company in need of strong oversight and clear direction from this commission. Northwestern will tell you that all of these background events are outside of this docket, but MEIC submits that now is the time for the commission to take a proactive role to steer Northwestern, arguably the most economically important company in Montana, onto a course that serves the public interest. The commission is invested with the full power of supervision, regulation, and control of public utilities such as Northwestern. And a general rate case is a comprehensive review, not just of the company's revenues, but also its risk mitigation and planning. And now is exactly the time for the commission to exercise its oversight. It should not punt on these issues by approving the partial settlement before you. Customers will benefit from a full adjudication of the questions posed in the testimonies submitted. With that, I'll call our first witness, Mr. Carl Rábago.
Mr. Rábago, can you hear us?
Yes, I can. Thank you, sir.
Okay. Have you been sworn in yet, Mr. Rábago?
No, I have not.
Okay. Would you raise your right hand? All right. Do you swear the testimony you're about to give is the truth and nothing but the truth?
I do.
All right. You're a witness.
Good morning, Mr. Rábago. Can you please state and spell your name for the record?
Sure. My name is Carl R. Rábago, and that's spelled Karl, middle initial R, last name Rábago, Rabago.
Thank you. And did you prepare testimony that was pre-filed in this docket?
Yes, I did.
Did you also prepare a correction to that testimony that was filed on February 9th, 2023?
Yes, I had made a calculation error on some numbers I cited on page 28, and we prepared a correction and submitted that.
Thank you. I emailed you a copy of your testimony with the file name 2022-12-19, final Rábago testimony with corrected page 28, along with 24 exhibits. Do you have that file in front of you?
I have the electronic version in front of me, yes.
Okay. And does it appear to be a true and correct copy of your pre-filed testimony as corrected in February?
Yes, it does.
Would your answers in that testimony be the same today, except for any additional corrections?
Yes, they would.
Do you have any additional corrections?
I do not.
Okay. I'd like to mark that testimony with the exhibits as exhibit MEIC1 and move it into evidence.
Okay. Any objection to the admission of MEIC 1?
Mr. President, if I may.
Of course.
Northwestern, for the record, and to preserve for appeal, renews its objections to the exhibits KRR3 and KRR4 that are attached to the pre-filed testimony of Mr. Rábago. These exhibits are inadmissible hearsay for which no exception applies.
Mr. President, for the record, may I just respond briefly?
Yes, of course.
We respond to the objection for all the reasons the commission stated in its well-reasoned order overruling Northwestern's previous objection in its motion preliminary. And I would add that the exhibits noted by Ms. Norcutt are not cited for the truth of the matter they asserted. Rather, the points that Mr. Rábago makes in his testimony are the opinions he levels are what his testimony or what our case relies on.
Okay. As previously determined by the commission, we are going to overrule that objection. However, I do note for the record your objection for purposes of appeal. Any other objections to the admission of MEIC 1? Seeing none, MEIC 1 is admitted.
Thank you. Mr. Rábago, I'm going to ask you just a couple of questions about the partial settlement and stipulation reached by certain parties in this case. Have you reviewed that stipulation?
Yes, I have.
And do you have an opinion about whether or not the commission should approve that stipulation?
Yes, I do have an opinion. I first want to express my gratitude to the president and the members of the commission and all the parties for accommodating my virtual appearance in this hearing and coming to you from Tokyo early or late this evening. And regarding the stipulation, I note that it is a partial stipulation and that while it asserts that it addresses all the outstanding issues in a rate case, as settlement stipulations typically do. I find it lacking in the sense of it putting together a comprehensive public interest case, and in addressing some of the issues that I raised in my testimony. Notably, there is an awful lot of interplay in this case about the Yellowstone generating station that is under construction by the company and its regulatory treatment and potential inclusion in rates. I was hoping that with this case, the withdrawal of the reliability rider, which was a positive proposal, which was a positive step in the settlement stipulation, that we would have a meaningful opportunity to see a presentation on why and an adjudication of why the generating station was the least cost, best solution that met an identified need for generating capacity in Northwestern's system. Unfortunately, I think that the settlement resolves the issues primarily by kicking the can down the road. There remains significant uncertainty as to when and how prudence of that decision to construct that generating station will how that process will be conducted and when it will be conducted. It could be in a PCAM proceeding. It could be in a subsequent rate case. I will also say that there are a couple of other features of the settlement which I didn't address in my testimony, but which stand out as noteworthy and very concerning. That is a 28% increase for residential customers in these days coming out of COVID and dealing with inflation. That's a pretty hard hit to residential customers, and it seems to me the kind of thing that would be a product of a settlement negotiation, but not likely consistent with the full adjudication of the issues. I see a novel, to me, very extremely unusual. I've never seen operating and maintenance expenses for a yet unbuilt generator proposed for recovery through tracker mechanisms. I don't know that there is a attrition or lag issue associated with such expenses, and the plant hasn't even been approved. So I'm concerned about that kind of approach. I think it replicates some of the kick the can, have the fight later when it becomes almost too late to have a meaningful discussion about the proposal's approach that I saw in the original case. And like I say, I think they haven't really been addressed here. I don't think this is a good public interest proposal for a resolution of the issues in this case, and therefore I would not recommend that the commission approve it. In fact, I'd recommend the opposite, that they disapprove it and have a fully litigated rate case before them.
Thank you, Mr. Rábago. I tender the witness for cross-examination.
All right, so just a housekeeping matter, Carl. Montana Constitution requires us to provide public comment on any matter that comes before us. And so we noticed it up for 9 a.m. our time. So there might be a break in your testimony. I apologize for that because I know it's late in Tokyo, but thank you for accommodating us in that regard as well. Okay. Cross-examination, Northwestern Energy.
No questions. Thank you.
Mr. Brown.
No questions, Mr. Chairman.
Mr. Nelson, I won't overlook you this time.
Good morning, Mr. Rábago, or good evening where you are, I imagine. I don't know if you can see me. My name is Thor Nelson. I'm an attorney for the large customer group in this proceeding. Can you hear me okay?
I can hear you just fine, sir. I cannot see you. So don't be afraid to speak up.
Okay, very good. I have a few questions about the testimony you've offered this morning regarding the stipulation. First, I want to start with what I think might have been just simply a misstatement on your part. So I just want to clarify for the record. As I took notes from your testimony this morning, you suggested a concern with the stipulation because you indicated that it proposed a 28% rate increase for residential customers. Did I hear you correctly?
I think that's what the number pencils out to. If you go back to the rates prior to the interim rates, that maybe that calculation was done rather quickly. So subject to check. I'm open to a discussion that it may actually be less.
Do you have a copy of the stipulation before you? What's been entered into the?
I have it. I have it in. Yes, I do. I have it in front of me. I can get those tables out. There's an 18% residential increase listed here, but I understand the current column. I thought the current column was the interim rates.
Okay. So
If
the current column is not the interim rates, if that is instead the rates that were part of the company's direct case, would that change the testimony that you provided? And would you agree then that it was an 18% increase?
Well, no, I'm not sure the way you said that, because you're saying if the light blue column on table 1 appearing on page 4 is if that current total revenues is what was filed by the company and entered in as interim rates, those would not have been let me put it this way. If that's the starting point and you do the math with total settlement revenues, then the residential increase is 18.2% is calculated. What I'm saying is that if you go back all the way to the rates before interim rates were approved, which is a different way to do the math, I think the overall increase is into the area of that 28%. So as presented, I agree with you, 18. I'm suggesting that there's a broader way to look at it by going back to the previously approved rates before the interim rates.
So just to maybe clarify, your opinion is that the stipulation calls for an 18% rate increase for the residential class on top of the interim rates that were approved by the commission. That's your understanding of the stipulation.
Mr. President, commissioners, can I object to this line of questioning? We received a residential bill impact analysis showing a 28% increase to residential customers just yesterday morning. Mr. Rábago is traveling and relying on a summary of that evidence, and I think Mr. Nelson's cross is misstating the evidence before the parties.
Mr. Nelson.
I'm simply trying to understand the basis of this witness's opinion. I am not making a statement at all. And so I'm not sure what the nature of the objection is. I'm trying to clarify this witness's belief that the stipulation contemplates a rate increase on top of the interim rate increase. And I'm trying to understand if that's the basis of the testimony he's given.
All right, so I'm going to overrule. So Ms. Harbine, you'll have the opportunity to redirect, and then you can clarify the point that I think you're trying to make. All right, Thor, go ahead.
Mr. Rábago, do you recall the question?
Yes, I do. And as you stated it, the calculation, I think what you're stating is a description of table 1, and that would be that there is an 18.2% residential increase from current total revenues, which I describe as the interim revenues, and going from that 243 million to 288 million with the total settlement revenues, a $44 million increase. I may be wrong about exactly what those numbers represent, and whether I'm labeling them correctly. So I am not saying 28% on top of rates prior to the filing. I am. Sorry. I believe that's what that summary statement was about, was a total increase from rates before the filing of the rate proposal in this case.
Okay. Mr. Rob,
And I should say, just for perfect clarity, 18% is still pretty big if you calculate it that way, and there's only 2 classes that get an increase that big. And I know there's a big potential big discussion underneath that about allocation approaches, functionalization, classification, and the process that goes into dueling cost of service studies. What I'm trying to draw attention to is the fact that there is an extremely large increase for residential customers coming at very tough economic times in what we in the business you may too call a black box settlement, with a bunch of other issues. And my suggestion, my recommendation, my opinion would be that all these costs and the distribution of costs as revenue requirement should be reviewed in a fully litigated proceeding.
thank you. Appreciate that. Let me then ask you this question. Do I understand the scope of your testimony correctly, that you have not presented to the commission a recommendation regarding the revenue requirement for Northwestern's electric service that the commission should award in this proceeding, correct?
No, sir. That is correct, that I did not.
And you have not recommended to the commission a particular approach with respect to how any rate increase should be allocated amongst and between the customer classes, correct?
No, I have not.
And you have not presented any information to the commission regarding what a cost-based rate would be for the residential class in Montana, correct?
That is correct. I have not.
Relative to the stipulation, however, would you agree with me that the stipulation does accomplish your recommendation as it's presented in your testimony to not have the approval of the proposed reliability rider, correct?
Very technically on that, the stipulation does say that a reliability rider will not be approved at this time. However, I will say that the way the stipulation addresses the Yellowstone costs might in some ways be worse than the reliability rider that was proposed. We don't know when a prudence review will happen. We don't know when a full featured evaluation of the need and least cost character of that generation station will a determination of that will occur. We have a potential for some very subjective categorization or unmeasured let's just say hard to pin down calculation of operating and maintenance expenses associated with a generating plant that hasn't been built being put into a tracker. The reliability rider was going to be like a tracker. So there, eh, well, and from looking out at the financial situation the company was proposing to put itself in, that prudence and allowance of costs would possibly not even occur until after all the money to construct and commission the plant was spent. The stipulation technically allows that same thing to happen, if I understand it correctly with paragraph, I believe it's 15, that the company does not have to file anything showing the prudence or wisdom of the generation station's construction, and would leave things where they were proposed with the liability rider, which was it show up, well, they could start collecting some costs and it would show up with a full review of costs in a rate case that is not specified as to time or scope.
Mr. Rábago, is it your testimony that the Montana Commission is required to make a determination of the prudence of utility investment prior to that investment being placed into service?
No, my testimony is that it is wise. It is especially wise for the company to seek some kind of pre-approval of the prudence of a major investment like a generating station, Yellowstone Station in particular, in order to minimize the breadth, the span of financial risk that is loaded into the commission's ultimate determination of rate treatment for such capital investment.
Would you agree with me, Mr. Rábago, that in the ordinary course of business, Northwestern's utility investments are adjudicated for prudency after the assets are constructed and brought into service?
Yes, and we may be getting really finely detailed on prudence. My experience when I've rolled on rate cases, it's the final box of receipts that ultimately gets the prudence review. But there are pre-approval processes that parameterize the spending, the commitment, the need, and the nature of the solution for that need that make prudence more of a checkoff and review of construction execution than all the other foundational questions. I was saying it again, like need and least cost solution.
I'm going to pause here. I'm observing it's 9 o'clock and I wanted to, Mr. President, turn it back over to you for the public comment issue.
Sure. All right, Carl, thanks for being on standby here for a minute. Okay, the time is now 9 a.m. We are going to move out of the evidentiary portion of our hearing. We're going to move into the public comment portion. All right, so we do have in-person and online public commenters this morning. As has been the case throughout this hearing, we will start with the in-person commenters. We are limiting public comment to 3 minutes each in order to accommodate witnesses like Carl, who are participating in unusual circumstances, to say the least. So I will call you by the order in which you signed up. Please come to the podium to my left, towards the front of the room. All right, is Mr. Ben Forsyth in the room? Mr. Ben Forsyth? Do not see Mr. Forsyth. We'll circle back to him. I did see Representative Butcher. I thought he was in the room. All right. Hi, Ed. Come on forward, 3 minutes. Welcome. Please state and spell your name for the record and where you're from.
Thank you, Mr. Chairman and members of the commission. I am Ed Butcher. I'm currently the state representative from House District 29, which includes the town of Winifred. And since I understand the Sleepy Hollow acquisition is something that's been under consideration by the board, I wanted to comment and representing the people in Winifred. This was critical when it was Northwest Energy stepped up and took over that gas-fired operation. That it was the middle of winter. There was no other alternatives for the people. The company had filed bankruptcy. And so the people in Winifred are eternally grateful that the commission was able to work with Northwest Energy and work out arrangements so that they could assume the power or the gas delivery system in Winifred. There's about 100 customers, I viewed less than that, somewhere in that neighborhood that are serviced by that group. So it was very, very critical to the area. And I want to emphasize that there were no other alternatives. There was a $50 million high school just being completed. There was a lot of concerns about, there was nobody there to look after the gas situation as far as safety and other things. There was a lot of issues that we were concerned about in the community. So that was basically my comments, Mr. Chairman, is that I really do, with the community of Winifred is very appreciative that they were able to assume this kind of orphan gas company that had been left stranded. So thank you.
All right. Thank you, Representative Butcher. Good to see you and thanks for coming today. All right. We'll circle back. Is Mr. Forsyth here? All right. Our next public commenter then is Jasper Schur. Welcome, Mr. Schur. Please state and spell your name for the record and identify where you're from.
Hey, I'm Jasper Schur, JASPER I'm from Livingston. My mother works in one of the elementary schools in Livingston. The kids she works with was the first thing she brought up when I explained this rate case to her. She said she can always tell the rich kids from the poor kids, not from their clothes or the things they bring for lunch, but from their energy levels. The poor kids are always tired and they're sick way more often. Some of these kids don't get proper sleep because their parents can't afford to keep the heat on in the winter, so they go to bed cold. One of the kids she works with is heavily immunocompromised due to a condition that leaves her in a similar state to Stephen Hawking. If her parents can't afford to keep the heat on in the winter and she gets sick as a result of it, it could be deadly. I want you to keep that in mind.
Thank you, Mr. Schur. All right, our next public commenter is Ben Tintinger. I hope I got that right, Ben. I apologize if I didn't.
That's close.
Welcome.
It's Tintinger. My name is Ben Tintinger. I'm from Helena here. Spelling of my name is Tintinger. And I am an owner of a business, Mosaic Architecture. I've had a relationship with Northwestern Energy for quite a number of years. We've worked on a number of projects together. So I'm here with a little bit of hesitation. It's hard as a consumer to come in and say, geez, I want to see my rates go up. But I want to speak to just the integrity of the company and my relationship of working with Northwestern Energy and how that I guess reflects on my belief that they're good people doing the right thing. I don't have the research and data that would justify this, but I do know a lot of the people, and I think they are working hard to make the right decisions as you are as well. As a business owner, we see and my business is architecture. I'm the principal of Mosaic Architecture here in Helena. We're involved in the construction industry. We see costs going up everywhere and how those are reflected on businesses. So I can understand as Northwestern Energy looks for the future on what it might take to satisfy staff wage increases, the cost of doing business, construction costs. How do they cover that? Whether that justifies this rate increase, I don't know, but I know again that they're good people doing good work, and I'm going to trust the system and trust the folks that are telling me that this is justified. So I understand that you all have a tough job, and I just want to voice my support for Northwestern Energy as a company and the folks that are doing the good work there and serving Montana. Thank you very much.
All right. Thank you, Ben. Thanks for coming today. It looks like we have Mr. Forsyth in the room. Mr. Forsyth, welcome. Please state and spell your name for the record and identify where you're from, please.
I'm almost totally deaf. You got a wonderfully soft voice. If I brought my wife in, could you teach her to speak that something? State my name. Ben, B-E-N, last name Forsyth, F-O-R-S-Y-T-H, like the town of Forsyth. Okay. May I go ahead and talk? Okay, thank you. I'm here today to address that. Thank you. Okay. I'm here today to address concerns that hundreds, if not thousands, of people have concerning marijuana cultivation and not only the harms it creates to people and users, but also to the environment. Okay. And I understand that's part of your jurisdiction. So that's why I'm here today. Please let me. Okay. Marijuana is, recreational marijuana is one of the most rapidly increasing legal and illegal commercial products in the world today. It is affecting Montana. It's affecting the environment. And let me explain exactly what I'm talking about. Okay. It uses massive amounts of electricity for indoor growing. Indoor growing is specified by the law in the state of Montana. Okay. So we must grow recreational marijuana indoors. And it uses massive amounts of electricity. I broke my glasses coming in, so I apologize to you. Just to give you an idea of what kind of electricity and how much, a 5,000 square foot indoor cannabis facility, and there are dozens in the state of Montana. I know of 4 just outside of Great Falls. Uses about 30,000 kilowatt hours of electricity a month. That is compared to a normal household that would use about 630 kilowatts of electricity in most of the state. Okay, it uses massive amounts of electricity. And because it uses so much, it drives the price up. And this has happened all across the Western United States. I give you a comment from an individual. Where did it go? Anyway, that says, this is from the Northwest Power Conservation Council in Oregon. And the head of that council says use has put a considerable strain, marijuana use and its growing and cultivation has created considerable strain on public utilities and has predictably driven retail electrical prices up. And we're seeing some of that today. I do agree that marijuana creates tremendous demand. The individual on the southeast corner of Great Falls out in Gibson Flats has 4 buildings that are each roughly 5,000 square feet. They raise over 6,000 marijuana plants per cycle, and the cycle can be 4 to 6 months depending on the type of marijuana.
Mr. Forsyth, you have about 30 seconds left to testify.
Now, I'm almost deaf. Sir.
You have about 30 seconds left to testify.
Oh, boy. It uses massive amounts of water also, and this is very, very critical. It creates huge amounts of sewage that can be polluted. And I think that's very, very critical. 17 people died in Pittsburgh in 2017 because of marijuana contamination. Hundreds of people were sick and hospitalized in San Francisco 2 years ago because of marijuana contamination. We've got to be very, very careful there. And I think that's within the jurisdiction of this organization. There are solutions that would provide considerable income to the
I'm sorry, Mr. Forsyth, I'm sorry to cut you off, but your time is up. We do have your written comment.
Yes, sir, and it's in there, and I would love to hear back from you. My address and phone number's in there. I am new at this. I'm not experienced, and I do not know how to approach you and what to do, what to say to convince you of the problems here. That document will do that considerably. Love to hear from you.
All right, thank you. Thank you for taking the time to come down and speak with us today too.
I voted for you, sir.
I'm not going to touch that one. All right. Are there any other public commenters in the room? Public commenters in the room. All right, let's move to online public comment. Our first online public commenter is Mark Darden.
Good morning.
Yes, go ahead, please. Yes, welcome. Please state and spell your name for the record.
Thank you. My name is Mark Darden. Mark, M-A-R-K, Darden, D-A-R-D-N. And I'm a vice president for DNV, an international risk assurance consultancy with over 30 years of experience serving customers of Northwestern Energy in service of energy efficiency programs, which thousands of commercial and residential customers have benefited from. Northwestern Energy provides a unique role as the largest utility in Montana. And in this capacity, DNV is extremely supportive of Northwestern Energy being able to maintain its health and stability so that it can continue to offer the energy efficiency programs, rebates, and education offerings that enable customers across Montana to reduce their energy consumption and lower their electric costs during this critical decade of energy transformation. I'd just like to thank the Commission for allowing me to provide some comments today, and hopefully you all have a wonderful day.
Thank you, Mr. Darden. Our next online commenter, Kyle Comstock.
Yeah, thank you, Chairman and members of the Commission. Kyle Comstock, K-Y-L-E, Comstock, C-O-M-S-T-O-C-K. I'm a director of grid modernization with the Mosaic Company. We are a consulting firm that specializes in workforce development and operations efficiency. I've been working with Northwestern Energy since 2019. I'm here to show our support for Northwestern Energy through this rate review. The work that we do alongside them helps bring a lot of value to their ratepayers through increasing reliability and resiliency. I've been engaged with a number of team members at Northwestern and see the hard work that they put in and day out to improve the experience for their customers and the ratepayers. And just wanted to say thank you, Commission, for letting me speak today and show our support for Northwestern Energy through this rate case. Thank you.
Thank you, Mr. Comstock, for taking the time to provide public comment. Our next online commenter is Clint Caulfield. Welcome.
Good morning, committee members. My name is Clint Kelfel, spelled CLINT KAL, F as in Frank, ELL. I'm the Montana 811 Program Administrator. I've been in this position for 13 years, so been at it for a little while. I was asked to speak today in front of you, ladies and gentlemen, regarding Northwestern Energy's involvement in the 811 system, or more commonly known to most people is the call before you dig system. A lot of people believe that the call before you dig system is a state agency, which is not correct. As you probably know, the call before you dig system is a private association, or I should say an association of underground facility owners that join together and maintain a call center. In our case, we contract that out, but a call center that receives information about people excavating. The call center and the system then turns around and sends these excavation notifications out to the affected utility companies, at which point then they are required by law to go out and mark their underground lines. I'd like to point out that this private association is paid for 100% by our underground facility members. And so we do not receive any tax money to operate. Everything is paid for 100% by our underground facility owners. Northwestern Energy is our largest member, both in size of territory as well as number of locate requests received by any of our members. And the way we fund the system is through a charge per ticket. So Northwestern Energy is by far the largest contributor to our Association of Underground Facility Owners. They are probably also one of the largest excavators in the state. If you're looking at the number of locate requests that we receive from excavators. So they kind of work or involved in both sides of the system, either from an excavator standpoint or locating underground facilities. So the utilities have to pay for being part of the one call system, and then they have the additional cost of sending the locators out to mark those underground lines. And they can either have employee on staff, or they can hire a contract locator that does that. And by far the biggest expense to locating underground lines is actually the excavators, the people, the individuals that go out and find the location of those underground facilities using different locating techniques and marking it. So there's a tremendous amount of cost that's involved that I think is sometimes overlooked when we look at what any of our utilities contribute to society, because with them funding the one call system, there is no cost to anyone that calls in. So there's no cost. We don't pass that on to any of the excavators to contribute to it, to pay for those expanded costs. And there's a benefit that everybody has, of course, from one, not wanting to have service interruption, which of course is a big issue, but there's also a very large safety issue of making sure that these lines don't get damaged and the resulting death or injury or damage to facilities. So I just wanted to say that Northwestern Energy is an important segment of the underground facility program, or the locating program. They are very active in it. We have 3 board members on our board member panel. Okay. 3 members on there and are very active in all of our education process. So actually really close. That was all I had to add.
All right. Well, thank you for taking the time to call in and make public comment today. We appreciate it.
Certainly.
Is there any other public commenters online, Mr. English? He's shaking off. Okay. Thank you for everybody who took the time to come and participate in our hearing this morning and to provide public comment. Time is now 9:21 a.m. We will move out of the public comment. portion and move back into the evidentiary portion of our hearing. Thor, we had left off with you on cross-examination.
Thank you, Mr. President. Mr. Rábago, can you hear me?
I can, sir, and I'm back.
Very good. Okay. One of the issues that you mentioned in an answer to one of my questions earlier was a concern that the timing of a subsequent filing regarding Yellowstone County Generating Station was uncertain. Do you recall you mentioning that, sir?
Yes, I do.
Okay. Do you have the stipulation in front of you? I think you said you did, but just let me confirm you've got that document.
I do.
Can I ask you to refer to page 6 of that document and paragraph 15?
I have it in front of me.
Would you agree with me that this is the paragraph that discusses the potential path forward for the future treatment of costs associated with the Yellowstone County Generating Station?
I would agree with that description, yes.
Would you agree with me that the second sentence of this paragraph contemplates that the filing that Northwestern envisions making will be done so as to be effective so that the change, in the PCAM base costs and property taxes are effective on the date the Yellowstone County Generating Station is placed into service? Do you see that, sir?
Yes, just not to put too fine a point on it, but to be very accurate, what I was drawing my attention to was that the stipulating parties agreed that Northwestern may request a one-time PCAM base costs and property tax base reset to be effective on the date that the Yellowstone plant is placed into service.
Sure. Okay. So
I was focusing on May. I was focusing on May, and I read that as discretionary.
Of course. So would it be your expectation that if this filing were to be made, that it would be made roughly contemporaneously with the date the Yellowstone County Generating Station is placed into service, if and when that ever occurs?
Yes, there's also another sentence later on in the paragraph that says, if they make that filing, certain things happen as well, but that's the match date. Placed into service, I'm assuming construction complete and commission and the plant being commissioned for service.
Okay. So in that context, would you agree with me that if such a filing is made, that the entity that you're representing today retains all of the rights it would otherwise have to object to that filing?
I would assume that yes, every person who would have standing to participate in that proceeding could, and resources, I guess, would be able to petition for participation and raise any objections or support they wish.
If you go a little bit further down the paragraph, do you see the sentence, if YCGS is deemed prudent, capital cost recovery will be addressed in the next general rate review? Do you see that, sir?
Yes. So I assume it'd be something like a kind of a deferred accounting order or something where it would be something like that. I don't want to get too tight around the definitions of accounting terms, but that's what it sounded like to me, was some sort of the outcome of the PCAM filing, if made, would be that the company could book costs, those capital costs, and there would be terms and conditions for the booking of those capital costs into some sort of account. And then that balance would be introduced into a rate case filing to the company, I guess, elected to do so, and in the amount the company proposed.
Okay, Mr. Rábago, would you agree with me that there is nothing in this paragraph that discusses at all deferred accounting for the capital costs of YCGS?
Yes, absolutely. Right. And that's why I said kind of like. I'm not saying that there would be any of that would be allowed, but you have a prudence determination, and then you have a subsequent capital cost determination. And I mean, I would be surprised if the utility did not ask for something to account for the carrying cost of the capital expenses once a plant was put into operation and deemed prudent, but who knows?
Okay, well, let's go with your guess then. If the utility made such a request for deferred accounting, would you agree with me that the entity who you are here on behalf of today would have the right to intervene before the commission to object to that?
Yes, I would. Again, the same answer I gave before, right? Anyone with standing and resources could participate to express opposition or support to aspects of the filing, and ask that the commission listen to them. And anyway, yes.
Okay. And then last but not least, would you agree with me that the entity on whose behalf you are appearing today would also have the right to intervene and object in the company's, Northwestern's, next general rate review after YCGS comes into service to object to the ongoing capital recovery, capital cost recovery?
Yes, and that's the point I made in my testimony here today, or yesterday my time, but anyway, is that and the testimony that I filed in direct, which is that it creates a kind of a regulatory chicken game where we're pretty far down the road before we finally, get all the price tag. In this case, some period, if the company took advantage of what's in paragraph 15, they get a prudence determination of that they've spent all the money with no pre-approval process to address those issues I mentioned before, then without any date certain, sometime in the future, the utility could file a rate case seeking to add the approved capital costs into revenue requirement.
All right. Since you mentioned the pre-approval in your recommendation, can you look at page 16 of your testimony?
Oh, glad to. Just a second though. Let me tab over to that. Yes, okay. And 16. All right, I have it in front of me.
Do you see on page 16, starting at line 18, you have a portion of your testimony that identifies some number of states. I don't know how many that is. Let's see. Looks like 9 states who have statutory schemes that contemplate filing for pre-approval of major capital spending. Do you see that, sir?
Yes, and it's accompanied with a footnote with a long string cite.
Sure. What I think I wanted to ask you about, though, is I observe, is it not the case that in the states listed there with pre-approval statutes, Montana is not one of them, right?
That's correct. I understand that a statute with a pre-approval process was repealed or struck down, I should say.
And you don't cite to a certificate of public convenience and necessity statute in Montana either, right?
I do not.
Okay. The second recommendation that you make in your testimony, sir, regards the recovery of capacity contracts in the PCAM and excluding those from the 90-10 sharing mechanism. Do you recall that, sir?
Yes.
I don't know if you were listening to the hearing so far, but let me just ask, were you listening at all from the very fun place you are at for the testimony of Ms. Lael earlier in the hearing?
No, I was not.
Okay. I'm going to represent to you that under cross-examination, Ms. Lael testified that under the stipulation, the company's proposal to exclude capacity purchases from the 90-10 sharing mechanism was not accepted. If you would just,
Okay.
if you would accept that for the moment, and the record will reflect whatever Ms. Lael said, but if that is accurate, would you agree with me that that addresses fully the second concern that you raised in your testimony?
I'd probably need more time with it to really say fully, button that up that tight, but it definitely is what I was going after. All I had was that the PCAM was going to be consistent with the witness, what the witness had proposed, and I did not know that it was included getting rid of or ending the proposal to no longer do sharing on those capacity payments. So that's, I owe you a second one. That's a second good thing if that representation is accurate.
Okay. So let's then finally take a look at your third recommendation. Your third recommendation is that the company exclude from its cost of service the capital cost associated with the coal strip unit 4 generating facility, correct?
Yes.
Now, that is the only revenue requirement recommendation that you make in this proceeding, correct?
Yes.
What is the annual?
Well, I mean, in fairness, the reliability rider would have impacted, recovery of costs, and it had a process down the line. But yes, the specific number that I recommended, I agree with your phrasing.
Okay, very good. I appreciate that. What is the annual revenue requirement reduction that would result if the commission accepted your recommendation to exclude the capital costs associated with coal strip unit 4?
I do not know. I mean, the number, the 42.6 million in capital expenditures is the number from between 2008 and 2017. That's the number that I focused on in my testimony. How that would pencil out is, I assume you start with that number. I don't know if anything else changes on that or how it's in there.
So 42 million.
Because I'm sorry, annual revenue requirement or total revenue requirement. So I'm getting confused in my head. But if it's 42.6 million total, and you've got an annual, depreciation of that amount, then it varies. And so an annual revenue requirement would be different from the total revenue requirement. You can see how I'm not clear.
Yeah. Okay. So let me just maybe ask you this way. Am I correct that your testimony identifies what the capital costs are, but you have not quantified what that translates to into an annual revenue requirement figure, correct?
Right. Yes, that's correct.
You are aware, are you not, that under the stipulation, Northwestern has agreed to reduce its base rate revenue requirements by $24 million as compared to their initial filing in this proceeding, correct?
Yes, I think I could agree with that. They've agreed to reduce their base rate revenue requirement proposal or request. Where that request is, vis-a-vis where it should be, if you will, is something that I think should be worked out in a rate case with all these issues in there, as opposed to, you know, I've only done a few hundred rate cases either as a commissioner or as a party, and I know that when and my experience is that especially when settlements are likely, the opening number can be more of a negotiating tactic than a expected final amount necessary to run the company. People being people.
Okay. Appreciate that. What I'm trying to focus on is your recommendation. Would you agree with
Yes,
me
sir.
that the annual revenue requirement of your recommendation to exclude some $42 million of capital expenditures is almost certainly substantially less than $24 million?
The annual revenue requirement of a 42 million capital cost change. Yeah, that's what you're asking about.
Yes,
And
sir.
how that would stand to a revenue requirement decrease of about half. Yes, I would agree with you as your question. I mean, you know, extremely simply put, it take 2 years to get rid of, you know, to collect all the revenue for 40 million at 20 million each. So yeah, right. I see where you're going.
Okay. So at the end of the day, would you agree with me that relative to the sole revenue requirement issue raised in your testimony, the decrease in the stipulation from the company's proposed electric revenue requirement is greater than the impact of the commission accepting your recommendation regarding Colstrip 4, correct?
Yes, I see what you're doing there. And everything you said is true, but I'm sure there's a lawyer joke somewhere there about how useful putting those, and I'm a lawyer, putting those numbers together is. It's the point that I was trying to make in my testimony is not that the company could, you know, continue to operate, meet its payroll, provide the electricity and gas that everybody is depending on, electricity side focused here, with a reduction in $42 million in capital expenditures translated into a reduced revenue requirement. So that I applaud the negotiators, but I also know that you're not wanting to have a discussion with me, and I wasn't part of the negotiations about who traded what on and what somebody asked for and what somebody else asked for and how the soup was ultimately made. So I can't agree if you're implying that, you know, if the soup comes out $20 million less, that I no longer need to worry about the fact that $42.6 million in capital expenditures were included in the original revenue requirement, you know, capital expenditures that the company proposed, without commission approval of those amounts back in the black box settlement that I just cited in my testimony.
Thank you. I have no
So
further.
my issue is, yeah, I'm sorry. I'm just putting a point on it, and thanks for bearing with me. But the point of my testimony was how the company treats treated those capital expenditures associated with Colstrip Unit 4 and using the black box settlement in that prior case to act as if the commission had approved it when the commission expressly refrained from making a decision on that revenue requirement in the prior case. All that just cited what I'm.
Mr. Rábago, you froze for just a moment. Did you complete your answer?
Oh, yes, I'm sorry. I said, and so I just, the point I was trying to make about the capital expenditures, the capital investments, capital spending, did not translate into that number. I was just pointing out that the commission did not make a decision about the inclusion of those amounts. And I think I'm just repeating what I said. So I'll stop there.
Thank you. No further questions.
All right. Thank you, Mr. Nelson. Captain Duffy. Ross?
No questions from FEA.
Okay. HRC?
No questions, Mr. President.
Renewable Northwest?
No questions. Thank you.
Welcome back, Mr. Uda. Do you have any questions? Can you verbalize that? Thank you. Ms. Chanel?
Thank you, Mr. President. Good morning, Mr. Rábago, or evening, or whatever it might be where you are. I'm Monica Trenell, and I represent 350 Montana in this docket. Wanted to just follow up with a couple of questions for you. Let's talk about the general principles of rate making. If the utility were to file an application for a rate increase and there were no intervener testimony at all, would the commission be obligated to accept that filing as made by the utility?
Boy, I would play lawyer here. Well, yes, I think they're obligated to accept it. It is a offer of evidence to support a rate change. But in my experience and in general principle, the utility's offer comes with a burden that it must of production and proof, two burdens of production, so that application must have enough in it to satisfy the requirement of producing evidence to support a determination on the rates, and then the proof that the resulting rates as proposed will be just and reasonable, meeting what that and any other statutory or law requirement for commission approval of rates, usually just and reasonable rates. So boy, I overparsed that. I'm sorry, but I think I'm agreeing with you, but I'm picking at it.
Thank you. And when interveners do appear, as they have in this case, and they subject the filing to stress testing and cross-examination, is that adequate in and of itself for the commission to reach a decision that the application doesn't meet the just and reasonable standards? Or are the interveners obligated to produce countervailing testimony regarding alternative revenue requirements and cost of service?
Yes on the first, no on the second. No other party bears any burden of production and proof unless they choose to take it on. That burden, but they can. An intervening party can. I'm going backwards. An intervening party can say, "Here's a different cost of service study or a different rate design or anything else, and that the commission should approve that. In that case, that intervener would bear that burden. But if they choose not to do that, and they can provide competent, substantial evidence that the utilities, and that could be just simply in the form of cross-examination or contrary filings or, examination of the record, that the utilities filing is deficient in meeting that burden of production or burden of proof, then assuming it was, black and white like that, the commission would have to say, in light of that evidence, the utility has failed to meet its burden and could not approve those rates.
Thank you, Mr. Rábago. So given the fact that we have a filing seeking an increase of $150 million from Montana ratepayers, can the commission reject that filing? Can the commission reject this settlement and reach an alternative outcome that has a lesser amount for Montana ratepayers?
They can, but my general experience is they would do that through a full evidentiary hearing, considering all the evidence. So, the stipulation settlement agreement has, by its own terms, that if any single component of it is not approved by the commission, the entire thing falls apart. It's a universal, a comprehensive settlement proposal. The commission could also, well, actually, I need to stop. I'm not clear on the black letter law of whether what the commission has to determine regarding a proposed settlement. I will tell you that my experience is that, notwithstanding assertions of any of the settling parties, the commission still adds its own imprimatur that the settlement will produce just and reasonable rates in order to turn that into rates. But I'm not sure what Montana says is required in terms of a commission determination.
Okay, thank you, Mr. Rábago. Let's go to the questions about, you were asked by Mr. Nelson about the timing and the recovery and the settlement on paragraph 15. I think there was some maybe confusion, and I want to clarify for the commission what your testimony is and make sure I'm clear on it. So there was the question that was put to you was that in the ordinary course of business, is there a prudency review? The prudency review often happens after a plant is brought into service. What I want to ask you about is not the timing of the building of the plant and the prudency review. What I want to ask you about is the timing of when the cost of that plant shows up on our bills. So is it ever acceptable for a utility to put costs of their incurred expenses onto customers' bills absent any review by the commission?
Okay, how broad was that question? Because
let's talk about specifically about the gas plant in paragraph 15. So as paragraph 15 is written, would it be acceptable for the utility to unilaterally increase our bills prior to the commission reviewing those costs for any kind of prudency?
No.
Thank you.
A utility, there would be, I mean, the specific number might not be known. That's what you do with trackers and things like that. Or the nature might not be known, but utilities, I mean, this is, the first thing a utility will say to you is they only charge rates that are approved by the commission. That translated back is that they can't charge a rate unless it is approved by a commission.
Thank you, Mr. Rábago. I would like you, if you would, you were asked some questions about the 28%. So if you have, I'm going to ask you about 3 different documents. I'm going to ask you about the settlement, paragraph 15, Northwestern's Exhibit 50, which was handed out, I think, yesterday, and the large customer group Exhibit 5, which was discussed yesterday during the hearing. So if you could have those 3 documents in front of you, I'd like to ask you a couple of questions about those and where that 28% comes from.
Okay, I want to get to nomenclature, exhibit and numbering. The
Yep.
second one you mentioned is probably the total bill impact spreadsheet, right?
Northwestern Exhibit 50 was the bill. It has electric bill impacts up in the upper
Yes.
left-hand side. And it has the change from August 22 to settlement in it.
Right. Okay. Yes, I've got that. Okay, that's the second one, Exhibit 50. And the third one was the large customer document you said?
Exhibit 5.
Okay. Gotcha.
Okay. So I want to ask about this question about this 18.2% that shows up in table 1 of the settlement at page 4, and then these other 2 documents. So did you hear Mr. Bieber's testimony yesterday during the hearing?
No, I did not.
Okay, so I will represent to you that Mr. Bieber, in discussing the last column of the large customer group Exhibit 5, which is picked up in the settlement at page 4 at table 1, that increase, both the dollar amount and then the percentage, is the same in Exhibit 5 as it is in the settlement. I will represent to you that Mr. Bieber agreed that 18.2% is 44 million, is 18% of 81 million. Are you with me?
44 million is 18% of
44 million. No, I apologize. I apologize. Sorry. I'm sorry. The 44 million is 18% of the revenue at current rates, which is in the first column, which is $243 million.
Yeah, right.
Are you with me?
Yes. That's what table 1. Yes, and it's in the other. Yes.
Okay. So the only relevance of this 18.2% is the $44 million as a percentage of the revenues of $243 million.
Yes.
Okay. Thank you. But $44 million is actually, and Mr. Bieber agreed yesterday, 54.1% of the 81 million that is proposed in the settlement. Are you following me?
Yes.
Okay. And then the next number in that column, which is also in table 1, 32 million, is 13% of the revenues of 236 million in the first column. Are you following me there?
Say that one more time on those numbers.
Okay. Yeah. And this is Mr. Bieber's testimony. The 32 million allocated to the GS1 is 13% of the 236 million revenues at current rates.
Yes.
Okay. But it's in fact, it's 39% of the total increase here of 81.9 million. Are you with me? Okay.
Yep.
Okay. And so adding those 2 together, Mr. Bieber's testimony yesterday was that the residential and the small businesses are picking up 93% of the 81.9 million increase being asked for and agreed on in the stipulation. Are you with me?
I see. Yes, you're just summing those 2 percentages, and dividing them into the total amount of the $89 million increase.
Yes.
Right.
So in fact, the settlement where we have this 18% and the increase, that's really an almost irrelevant data point. And what is important for the consumers to know and the commission to consider is the total increase that's being borne by residential and small business customers. Would you agree with me on that?
That's a relevant data in there, but I think that's the biggest and most important one is like who's getting, who's bearing the burden of the revenue requirement increase.
Okay, thank you, Mr. Rábago. So then I want to shift because those two tables and data are talking about these people as a class of customers, correct?
That's yes.
Okay, none of which is really relevant to the person who's living in a house and turning on their heat, and that is about the bill impact to one single person or a small business in one of our towns, right?
Yeah, that's right.
Okay.
Energy burden or allocation of burden, yes.
Okay, so let's look at Northwestern's Exhibit 50, and this is a bill impact. So this is how it affects each person and each business. Would you agree with that?
Yes, definitely bill impacts is something you would look at in this, but this includes an assumption. It's an assumption of a usage level. Typically, these are done with average usage numbers, and of course, there's practically nobody that's average.
Okay. So with that caveat, what we're looking at in Northwestern Exhibit 50 under the change from the August 22 rates to the settlement, what you see there under the residential rates is an increase of 28%, correct?
Yeah, that's the number that I was referring to earlier, and it's the product of dividing $25 in change in the change of the bill for this. I presume is an average customer between August 22nd and the settlement.
Okay, and would you agree with me that a 28% increase is significant?
A 28% increase in any individual rate would be significant. A 28% increase in the average bill is especially significant because there's a certain amount of economic regressivity in the distribution of customers within a class, meaning that very often low wealth customers on fixed incomes like retirees, students will be low users, and the energy burden that they will perceive, the change in the energy burden will be greater than somebody like me who has a relatively large electric bill and a fair amount of disposable income.
Mr. Rábago, what happens when people can't afford to pay their electric bills?
Well, I think the general truism is that one of two things happens. Mostly, people try hard to find a way to pay their bill. And sadly, that means they will forego spending on other things, including medicine or food or other things. So generally speaking, customers try to pay their gas and electric bills and their water bills, their basic utilities. They're sort of basic on your Maslow's hierarchies. But the second thing that happens is that they will stop using the energy and or the service, and they will suffer, deprivation of the benefits. So they'll be cold, or they'll be they'll be cold, or they'll be too hot, or whatever, or they will try to continue using that service until they get hit with disconnection, reconnection fees. They have to take time out of their lives to try to seek assistance. It really can turn a family life, upside down.
Thank you, Mr. Rábago. I have no further questions.
Thank you, Ms. Trinnell. Any other, Ross? All right, seeing none, this will be the time for commissioner questions. Vice President Fielder. Okay, go ahead.
Thank you, Mr. President. Most of my questions have been answered through the council's questioning, but Mr. Sorry, Rogala? No.
It's Rábago.
Rábago. I'm sorry. I had it.
Do not worry. Don't worry about it.
All right, Mr. Rábago, this is Commissioner Jennifer Fielder, and I just wanted to follow up on a couple things you just mentioned. I noticed that as you were just answering the previous questions regarding what would happen if somebody felt like they couldn't afford their energy bill, or if their energy bill was too high. And I think you went to 2 points. One is they would reprioritize their expenses. Is that correct?
Yes, that's a simple and general way of saying it.
Okay. Does that mean that they would necessarily be deprived of essential things like medicine, or may there be other expenses that they would reprioritize so that they could pay their energy bill first before they purchased other things that maybe weren't necessary, weren't essential?
Yes. Yes. I mean, if it's enough, right? So that the issue, one of the reasons why we focus on energy burden when we talk about low wealth customers, is that it's not like, for me, do I buy an extra cup of coffee, which is a small amount of spending, and reprioritizing around that is no big deal. The electricity or gas bill, can be 10-20% of a customer's household income, and the options for reprioritizing can be limited because of the magnitude of the burden, the energy burden that the customer is experiencing. But yes, it's kitchen table economics. We've all done it, right? You sit around and say, I got this many needs and I got this much in the wallet, and I got to figure out what we do and who we ask to wait.
Okay, thank you. And I was also curious about your response regarding the other part of your answer, and that was that they may reduce their energy usage. Does everyone who reduces their energy usage suffer?
No, and that's a really good point. Some customers can be motivated by high bills to the joke I've often tell is teach your teenagers to close the refrigerator door. Stop staring in there looking for a snack, or turn off a light, or something like that. So reduction in use does not necessarily equal privation, but same caveat as I just mentioned, which is that when you have an extremely high energy burden and tight household budget, then it's more likely that high bills or high unpayable bills will lead to privation, and what some people call that energy insecurity.
Thank you. I think that's all the questions I have, Mr. President.
Thank you, Vice President Fielder. Commissioner Pinochi,
No questions, Mr. President.
Commissioner Bukacek. All right, I don't have any questions for this witness, Mr. Hamilton.
No questions, Mr. President.
Okay, Ms. Harbine, your witness is, I think, past the midnight hour at this point in time. How much? Oh, we would have the opportunity for recross. Aye. Okay, well, I'm sorry to do this to you, Carl, because I know how late it is for you. We've been going at it for an hour and a half at this point, and some folks are asking for a break. Would you mind sticking with us for 10 minutes?
I'm happy to. You're accommodating me, so thank you very much. I'll hang for 10.
Okay, well, thank you. Thank you for accommodating us, actually. All right, the time is now 10:07 a.m. Why don't we take a 10-minute break? We'll come back at 10:17. And with that, we will go off the record. All right, the time is now 10:19 a.m. We will go back on the record. We just finished with commission questions. Recross, Northwestern Energy. Mr. Brown, you miss out. Mr. Nelson. Captain Duffy. McGraw. Renewable Northwest. Mr. Ruda. Ms. Trinnell. Okay, seeing no recross, redirect.
Mr. Rábago, I have just a few questions remaining for you about some questions that Mr. Nelson asked you on cross-examination.
Okay.
First, Mr. Nelson asked you about the impact of Northwestern's inclusion of approximately $42 million of pre-2018 capital expenditures in the rate base. Do you recall that?
Yes, I recall the discussion.
Did you hear Mr. Nelson's opening statement in this case?
I did not.
Okay, I'll represent to you that Mr. Nelson stated that the stipulated revenue requirement is roughly the midpoint between Northwestern's proposed revenue requirement and the large customer group's proposal. With that understanding, what is your opinion regarding the impact of Northwestern's coal strip rate base on the stipulated revenue requirement?
I don't know how to draw a connection between them. I don't think you can. I mean, I've assumed the company started with its number and included it, and you know, like I said, I would not be surprised if they had a higher number for knowing they would be negotiating. I would assume that a ratepayer organization of any type would generally argue for a lower number. Those are bargaining positions, and knowing, like I said earlier on, knowing more and knowing what, you know, not knowing what was going on in the room. I don't know how to draw any connection between the two of them at all.
Okay, fair enough. Thank you. Mr. Nelson also asked you a series of questions about whether paragraph 15 of the stipulation, which is the paragraph that proposes to eliminate the reliability rider proposal,
Yes.
whether that resolved your concern about the reliability rider. Do you recall those questions?
Yeah, in fairness, I think I volunteered that while it was good to see the reliability rider be withdrawn or not go forward, a lot of my concerns that were at the heart of the reliability rider are not ameliorated by the revised approach.
Okay. Will you, just to get specific on that, will you turn to page 21 of your testimony? And
yes,
specifically, this is where you talk about the impacts of deferring questions of need and potential alternatives.
Okay, wait 1 second. Okay, line numbers, are you in the question that starts with line 10 on page 21 or earlier?
Just a moment.
Oh, it's earlier. It's before line 10. I assume the problems. Right. What I said was the problems associated with delaying review of the critical questions of need and of consideration of alternatives are significant. This is what I was trying to explain earlier on to Mr. Nelson, that we weren't getting a determination of least cost and need possibly until a rate case is filed by the company. And then what I said before the settlement, obviously, was proposal was for a plant that takes 3 years to build, for example, the company proposed ERR process would delay commission consideration until 7 full years after breaking ground on the project. I was just stacking up the timelines.
Okay, so just to clarify the record then, your testimony is that this issue is not resolved by paragraph 15, correct?
I don't think it's effectively addresses my concern of this, that you wouldn't really necessarily even get to the question of whether this is the plant, this is the money, the spending that's needed to ensure safe, reliable, adequate service for, it doesn't do that because as I read it, the company has the option of not even addressing the prudence of the Yellowstone plant until it chooses to file another rate case.
Okay, so your testimony though is that the deferral of questions of need and alternatives are not resolved by paragraph 15, correct?
Yes, yes.
And on page 22 of your testimony, you talk about Northwestern's actions, to paraphrase, you failed to promote a constructive regulatory environment. Is that a fair characterization?
Yes.
And is that concern resolved by paragraph 15 of the stipulation?
No, that was what I was trying to make about the idea that there's this game of regulatory chicken, as I called it, where the company essentially, bets that the commission won't deny significant components of spending after that major investment is made because changing course would be so hard. And having been a commissioner, well, I never wanted to manage the utilities I regulated. And later on at utilities, I learned that managing is pretty hard and deserves huge respect. But I also, I think that the commission has a role to play in acting as a substitute for the forces of competition. And they do that by the utility ensures that they maintain a constructive relationship with their overseer by telegraphing their actions as much as possible and socializing their intentions and being transparent with their plans.
Thank you, Mr. Rábago. I have no more questions for this witness and would ask that he be permanently excused.
Any objection to this witness being permanently excused? Seeing none, Carl, thank you so much for participating in today's hearing. I hope you can get some sleep.
I will.
Thank
you very much.
All right, thank you.
Bye-bye now.
So I just wanted to clarify, Ms. Harbine, you're reserving calling an additional witness, correct, at this time? Okay, well then where I think we left off was Mr. Dismukes was on the stand. So if you'd approach and. Good morning and welcome. You were sworn already, correct?
Yes, sir.
Okay. Commission does have a few questions to ask you before we go back to recross.
Okay.
So, Mr. Hamilton.
Thank you, Mr. President, and good morning again, Dr. Dismukes. Could I refer you to your pre-filed direct testimony?
Yes.
And in particular, page 97. And
Yes, sir.
I'm looking at the sentence that begins on line 14 of that testimony. It says the alternative JCOSS, which is the jurisdictional cost of service study, estimates a FERC jurisdictional revenue requirement net of these ancillary service revenues to be $65.5 million and a MPSC jurisdictional revenue requirement of $99.6 million. Did I read that generally right?
Yes, sir.
Okay. You ultimately recommended that the commission use this JCOSS estimate of $65.5 million. Is that correct?
Correct.
And that is lower than the test year actual transmission revenues for Northwestern Energy. Is that correct?
Correct.
Because that dollar figure was around $79.4 million, correct?
Correct.
The difference between those two figures is about $13.9 million. Would you agree with that?
That sounds right. Yes, sir.
Okay. Can you explain why there is a difference between the JCOSS figure that you recommend and the actual revenues for the test year?
I think there was as I recall, a leap in that test year that was kind of out of trend from the prior 2 years of looking at that information. So that test year was pretty high. If you go back, I'm trying to remember, there's an exhibit where you can see that. Yeah, on TED 9. See that leap for the test year from 2021 between where you've got pretty good coverage in 2020 and 2019.
So is it your testimony that the 2021 test year was not representative?
Well, it was a little higher. So I think that had part of playing into a more conservative estimate.
Can you explain your understanding of the reasons for that leap?
I don't recall. I think I looked at it at one time. I just can't tell you as I'm sitting.
You would agree, though, that if the commission were to, one, not approve the settlement, and two, adopt your JCOSS recommendation, the revenue requirement for Montana retail customers would be $13.9 million higher than if we use the actual test year revenues?
Yes, if you use the test year, it'd be higher.
Okay. I think that covers my questions. Thank you.
All right, Mr. Dismukes. Okay, recross, Ms. Trinnell.
Thank you, Mr. President. Good morning, Mr. Dismukes.
Good morning.
How are you this morning?
Good.
Enjoying the snow from Florida?
I am.
Mr. Dismukes, would you agree with me that as an investor-owned utility, Northwestern's fiduciary duty is to its shareholders?
Yes, ma'am.
All right. And so part of its job is to make as much money as it can, right?
Part of its job is to maintain its financial attractiveness and create earnings. Yes.
Okay. When you were working through the settlement negotiations, did the Consumer Council advocate for any solutions that would have required management to bear some of the financial consequences for failure to plan?
Mr. Chairman, I'm going to object that this is calls for discussions that are protected under Rule 408 settlement discussions.
Mr. President, I'm not asking about the settlement negotiations regarding, and if you look at Rule 408 and what it actually says, I'm not asking for them to discuss the numbers that they arrived at. I'm asking him whether in broad strokes, in general terms, what kinds of issues were generally addressed and whether as a general principle, the Consumer Council did its job in advocating for the consumers of Montana and ensuring that the utility bears some of the financial consequences of poor planning. That's my question for this witness.
Mr. Chairman, it sounds like she's asking the witness to describe settlement discussions that are confidential. And I also, that this phase of the cross-examination is supposed to be limited to following up on commissioner questions and staff questions. So I guess I would ask what this line of questioning is following up on.
So I'm
I'm going to sustain the objection. So Ms. Tranel, you can continue with your questioning.
Thank you, Mr. President, and I trust the record will appropriately reflect the Consumer Council's desire to truncate the amount of evidence that's coming before the commission in this proceeding. Thank you. I'll move on. Mr. Dismukes, I believe you testified about your familiarity with a jurisdiction that, and I'm not sure I'm going to capture this correctly. I think you said there were no Territorial Services Integrity Act somewhere in Louisiana, maybe?
In Louisiana, we don't have predefined service territories like a lot of states do.
Okay. And so that would allow consumers to choose their provider. Is that how that works?
There are some limited provisions outside the boundaries of where utilities serve, where you see some cherry picking that can go on from time to time.
Okay. In terms of solutions
So
that,
excuse me, if I can clarify, give you a good example. In the Gulf Coast, we have a lot of industrial facilities, I'm sure you're probably aware of. So if you get a new industrial facility in there, sometimes you can have some controversies about which utility serves those loads.
okay. And I think Commissioner Pinocci was asking you about co-ops and Northwestern and aligning rates. If the commission were trying to come up with solutions about how can we, allow the utility to get the money it needs to provide service, but also protect ratepayers because they're trying to figure out how to walk the line, right?
Right.
So in terms of trying to figure out solutions for that, would one option be to remove the Territorial Services Integrity Act in Montana?
So I guess that would be an option. I think what I would say is I don't know that there's a full record to explore something like that in this particular rate case. And if the commission wanted to consider those things as a separate docket or a rulemaking, that could be something that could be examined.
Okay.
But I'm not prepared to give you a yay or nay on whether that would be good for Montana or not, because I haven't looked at that.
Okay. And I mean, I think the commissioners were, fairly grappling with what are our options here. And so just to follow up on those questions, and there were some questions about, how do you address the, true cost causers and figuring out how to allocate costs of service. And were you here to hear Ms. Lale's testimony about, haircuts and providing service for free? Did you hear her testimony?
No, ma'am, I didn't hear that. No.
Okay. So if municipalities are costing so much money to this utility, would one option be to let the municipalities go, let Bozeman and Missoula municipalize their electricity systems and provide their own service? That would certainly be an option, wouldn't it?
So again, like my prior answer, yes, there are options out there. Again, whether there are any merits to them, I don't know. I haven't looked at that. And I don't think in this proceeding, we've got enough information to make that decision. Could the commission open up a proceeding to look at those things? Sure.
Thank you, Mr. Dismukes. Mr. President, I don't think I have any more questions, but I do have an exhibit that is marked MCC 5 that I got for the first time this morning. And if there's some intention to have that come in, I would like to reserve the right to cross-examine every appropriate MCC witness on the exhibit when and if we ever talk about it. Thank you, Mr. President.
Mr. Brown, you want to address that?
Yeah, thank you, Mr. Chairman. We have prepared an exhibit that we've marked MCC 6 that I intend to seek the admission of when I redirect Dr. Dismukes, and it is in follow-up in response to the cross-examination he answered from Ms. Tranel regarding the bill impact analyses. And
Mr. President, I want the record to really clearly reflect what is going on here. This is the third day of the hearing. We're getting a Consumer Council exhibit for the first time on redirect. I want an opportunity. Everyone should have an opportunity to cross-examine this witness. This should not be trial by ambush, which is what's happening right now from the Consumer Council.
Mr. Chairman, maybe I can help. I don't have any objection to Ms. Tranel cross-examining Dr. Dismukes about this exhibit.
All right, so I just want to clear some things up for the record. MCC 5 was admitted. Okay, so now we're talking about MCC 6. Ms. Trinnell has lodged a objection request, perhaps is a better request. Mr. Brown has acceded to allowing Ms. Trinnell to ask about MCC 6, correct, Mr. Brown?
Yes, we have not yet sought its introduction, but I'm amenable to her cross-examining Dr. Dismukes on this whenever she would like.
President Brown and commissioners, if now is the time to lodge objections, I'd like to make one on behalf of MEIC as well. This exhibit was not identified in MCC's pre-hearing memos, much like basically all of the exhibits that have been introduced regarding the settlement at this hearing. It highlights for me the need for additional process related to this settlement. And I think we have been sandbagged with new information every morning of this hearing. And I guess I could make that a standing objection to new exhibits regarding this stipulation, but I'll offer one specifically related to MCC 6.
All right, does anybody else want to weigh in on MCC 6?
Mr. Chairman, can I just briefly weigh in, since it feels like the issue is maybe a little bit larger than just MCC 6. We also, Northwestern does not have an objection to further recross on MCC 6, but I do want to point out that the volume of information that has been produced is in direct request and response to what has been asked for in cross-examination. We're not trying to sandbag, we're trying to make sure everybody has as much information as possible. And we are all working all hours of the night to provide that information to the interveners, the non-settling parties, and the commission.
Thank you, Ms. Heim.
Mr. President.
Yes, Mr. McGraw.
Since everyone else is commenting, I might as well.
Please do.
I do think that the point Ms. Harbine made is a good one, that the process that was used here to consider and fairly adjudicate the settlement that's been proposed is problematic. I understand the difficult situation the commission was in, having a settlement filed 8 days prior to a scheduled hearing on a big case, and schedules are made around that date, were made around that date. I think I'm not going to sit here and say that there's a flat out due process violation. I'm not threatening that or even suggesting that that's the case. I understand you're trying to do your best to accommodate the parties, conduct a fair hearing, and dispose of this matter with, or handle this matter with due consideration. Nonetheless, I also think that this is an issue that in the future, the commission should consider carefully, take note of, and think about a way that to ensure that this doesn't happen again. Thank you, sir.
Thank you. Mr. Ruda.
Mr. President, what I want to say is I think the concerns you're hearing expressed, and I'm not blaming anybody. I mean, I think everybody's trying to accommodate things the best they can. But part of the problem with having a contested case hearing or a trial and not knowing all the evidence that's going to appear before the hearing starts is that you cannot possibly be prepared to adequately conduct cross-examination on things that either you haven't seen or you've just recently seen. And that puts the parties who are not involved in the settlement, because one of the things I've kind of been seeing, I'm not saying that this is my position at this point, but one of the things I've kind of been seeing is this kind of shifting of the burden of proof, if you will. So for example, there was discussion yesterday that I heard about, well, no other party produced a cost of service analysis or a rate design. That's really not our burden. It's the burden of the settling parties to prove the settlement is just and reasonable and in the public interest. It is very difficult to have a hearing where you don't know what the evidence is going to be in advance. And at the same time, have this sort of hazy shifting of the burden of proof. So I'm not saying I'm objecting to MCC 6. And I know Jason is a person of good faith, and I don't think that he was trying to sandbag anyone. But I do think that this is sort of a continuing problem. And it was kind of created by the process at the outset. And again, I'm not blaming anybody in particular. I'm just want to make this note as part of, I guess, a continuing objection to the process.
Mr. Chairman, if I might be heard, we haven't moved this exhibit yet. I guess I would hope to have an opportunity to lay the foundation and explain why I think it should be admitted before everyone piles on with their objections. I guess I'd just like to say that I agree with Shannon that all of these exhibits this week that have come in have all been related, I believe, to the bill impact analysis, which is the topic you're hearing discussed a lot in this hearing. And this is an effort, a good faith effort to try to clarify that issue. If this is not admitted, I can ask Dr. Dismukes the questions I need to ask him and get the information I think is important into the record. I think getting this in the record will be much more efficient and helpful both to the commissioners and the parties to see exactly what we're talking about and what the basis for his responses are. So I would also just add that MCC 6, I don't believe adds new information to the record of the evidence. It is simply a different presentation of numbers and information that is already in the record. Thank you.
I saw Council for Renewable Northwest pick up her microphone.
Thanks, Mr. President and Commissioners. And I would simply add that Renewable Northwest supports the objections raised here today, just on process in general. As our pre-hearing work was really focused on the reliability rider, which now with the settlement has almost kind of settled us out of this interest in this docket. And so while we do intend to offer our witness, we did still have the objection on process that was raised prior to the hearing, and join in the objections raised here today. Thank you.
Mr. President, Commissioners, to clarify our position first,
Ms. Harbine, can you identify yourself for the record, please?
Jenny Harbine for MEIC. I am sorry for suggesting that any individual or party is intentionally sandbagging the non-settling interveners. My point here is that I completely agree with Mr. Brown's comment that this is helpful to the parties and the commission to understand the impacts of the settlement. I would go further and say it's essential to understand the residential bill impacts to consider whether this settlement is in the public interest. And that's precisely why the non-settling interveners moved for additional process before this hearing began. And at this time, I'd like to renew that motion for additional process, and I will withdraw my objection to the admission of MCC 6, although I understand it has not yet been moved.
Okay, so let's cover, that was a wide range of discussion. I will say this. So let me address it this way. First is that thank you, Ms. Harbine, for withdrawing your objection and using the word sandbagging, not appreciated. I would just remind again, all council, the admonition I made at the beginning of this hearing that RPC 3.5 and 3.6 do stand here, and you're all working under those professional ethics constraints. Understood? All right, and in response to the standing objection, I would just remind the parties that I issued as the hearing, essentially the president or chairman of this particular proceeding on Friday the 7th, reasons for why we're moving forward with this. So I'm going to allow that to stand. And I would like that noted in the record, reference that parties were notified on Friday the 7th that we were moving forward in the process under which we are moving forward with this hearing. I would also note for the record that the scheduling order that was issued in this matter on September 14th, September 14th, 2022, set a deadline for April 3rd, 2022 for filing stipulations and settlement agreements, and set a hearing date for this week. I would say that that meets some due process. All right. So again, MCC 5 has been admitted. We are talking about MCC 6. I would like Mr. Brown, given the comments that were made by various parties in this matter, for you to go ahead and lay some foundation for this document with your witness. I realize that everybody has apparently withdrawn their objections from this, but we are going to do this procedurally correctly given this point in time. So Mr. Brown, would you please proceed?
One question, point of clarification, Mr. Chairman. Can I proceed to do my whole redirect now? Are we done with recross? It might be more efficient to do it that way, and I can cover that when I do redirect.
Okay. That's probably a good path to move forward. All right, Mr. McGraw, do you have recross? Renewable Northwest?
No, Mr. President, thanks.
Mr. Uda? MCC? MEIC?
I have just a couple of questions. Thank you, Mr. President, commissioners. It's been a bit now since you were questioned by President Brown, but I'd like to ask you just a few follow-up questions on that testimony. Do you recall President Brown's questions to you regarding whether there's any record evidence to support reducing the rate allocation for the residential customer class in this case?
Yeah, yes, I do. I believe the questions were geared towards non-settling parties or any other parties. Yes, I do.
Do you agree that your pre-filed testimony is evidence in this case?
Yes.
And you testified with a recommendation regarding maximum and minimum rate increases, correct?
Yes, ma'am. That's correct.
The stipulated revenue requirement exceeds for the customer class your recommended maximum rate increase of 1.1, correct?
Yes, ma'am. That's correct. And I discussed some of those aspects. I won't belabor those earlier on why we made those differences.
Okay. And do you agree that the increases for the GS1 primary and GS2 transmission classes are lower than your recommended minimum increase?
Yes, ma'am, I would.
Okay. And to affirm those recommendations can be considered evidence in this case.
Yes, ma'am.
You also submitted pre-filed testimony regarding the subjectivity and potential bias of certain embedded costs of service study methodologies. Is that correct?
Yes, ma'am.
And the need for regulators to apply policy judgment in rate allocation in light of those concerns about such studies. Is that correct?
Yes, ma'am.
And that's evidence in this case?
Yes, ma'am, it is.
And you submitted testimony regarding gradualism or discussed it in your live testimony?
Yes, I did.
And that's evidence in this case, correct?
Yes, ma'am, that's my understanding.
And then President Brown asked you about whether the non-settling parties submitted testimony with an alternative revenue requirement or alternative rate design in this case. Do you recall that?
I do, yes, ma'am.
In your experience, are such exercises in developing an alternative revenue requirement or an alternative rate design complex?
They are.
And resource intensive for your clients, correct? They cost a lot.
So if you're developing a cost of service study, yes, that would be true. If you're looking at recommendations relative to revenue distribution or rate spread, whatever terminology you want to use, in some parts that's not overly complex or overly involved in terms of the effort that has to go into that. At least my experience has been that way. I would agree with you on the cost of service approach. And then on some some aspects of rate design, that would be true as well. If you're getting in and formulating specific rate components in a rate model, that gets pretty complicated. But if you're making general policy recommendations with regards to, say, something like a customer charge and not increasing those don't really require, excuse me, a lot of intense work.
Okay, that's all I have. And thanks very much for your testimony.
You're welcome.
All right, I think that concludes our recross. So Mr. Brown, redirect.
Thank you, Mr. Chairman. And I'll go ahead and start by easing into the foundation for exhibit MCC 6. And to do that, could I have you start by looking at exhibit NWE 51? Do you have that in front of you?
So
I think Northwestern.
I was gonna say, I don't have that.
A copy with you.
You may approach.
Oh, okay.
And based on that note in the upper left, what is this table showing?
This looks like a variety of different a variety of different rate changes that have progressed across time from I believe the original filing through updates in the settlement process.
Okay, and what is that third? Why don't you just read the third line in the upper left there? What's the title of it?
Okay. Are you talking about
Starts natural gas? Does this show natural gas bill impacts?
Oh, yes, it does. Okay.
Okay, so NW 51 is an exhibit that shows natural gas bill impacts, right?
That's correct.
And for the residential class, there it's called residential services. What is the change from August 2022 to settlement?
It's a reduction of $2.98 or a 4% decrease.
I'm sorry, a 4% decrease. Okay. And do you have NWE exhibit NWE 50 in front of you?
I believe I do.
And what does that exhibit show?
Does 51 have 2 pages or 1 page?
51 has 2 pages, 50 has 1.
Okay, I don't have 50.
May I approach?
Okay, thank you. I have that. Yes.
So what does NWE 50 show?
50 shows bill impacts for electric.
Okay, and so for the same boxes for residential electric utility services, what is the change there from August 22 to settlement?
$25.36 or a 28% increase.
Okay, so the settlement on the gas side includes an increase in the rates, right?
Yes, sir, it does.
So why does the natural gas bill impact table show a decrease in NWE 51?
There were other adjustments that went beyond the base rate changes that we're talking about for settlement purposes.
Okay, so would it be fair to say colloquially there's other noise in this calculation?
Yes, sir, that would be correct.
Or that there must be other variables in this calculation aside from the rate case at hand?
Yes, sir.
So would that also be true for NW 50 where we see the 28% increase for the residential class?
That's correct. Yes, sir.
And for the electric side, on the electric side, what would some of that noise or some of those other variables be?
A big one has to do with supply related costs. PCAM has changed, the base has changed, it was updated. And then there's been a pretty significant deferral from prior year under collections.
have you prepared a spreadsheet that attempts to exclude PCAM changes from the bill impact analysis?
Yes.
Okay, and that's been handed out, Mr. Chairman, for the record as Exhibit MCC 6. Can you, I guess, describe for us, Dr. Dismukes, what you were attempting to calculate in this spreadsheet in MCC 6?
There's a lot of numbers and columns on this, and it looks really busy. But the real simple thing that I was trying to extract from this, as you alluded to earlier, is that there is a lot of noise in this and there's other things going on. And so when you're looking at a large 27.8, 28% bill impact, I think one of the things to keep in mind relative to what we've been talking about with regards to the settlement is that a big chunk of that is PCAM related or supply related. And so I'm not trying to diminish the importance of the rate increase or that it exists, but I do think it's important that the commission kind of get a feel for the differences in what's driving that 28% relative to what we were talking about earlier with the settlement and the tables that were included in the settlement agreement.
And does that 28% figure appear on your spreadsheet?
Yes, sir. It's down at the bottom, right? 27.8.
Is that column M, row 29?
Yes, sir.
And next to that is the 25.36 here, $25.37 amount.
Yes, sir.
And so how much of that excuse me, I misspoke, 25.37 increase is attributable to PCAM?
It's right at 50%, half.
Is that just PCAM or PCAM and property taxes, both?
That's PCAM. If you add the property taxes, it would be a higher percent, probably closer to a third, maybe.
Sorry, closer to what?
A third.
Okay. And can you tell us what?
I haven't done the math, but there's another, I think, $2 impact associated with that or so on property taxes.
Okay. How much of the increase percentage-wise is due to PCAM deferment?
It's about half of the PCAM adjustment itself.
So I'm looking at it, there's a little box that you've added to this spreadsheet that identifies an increase due to increase in PCAM deferment. Do you see that?
Yes.
And what's that percentage?
Well, it's a 4.6%, I believe, increase across the row. But if you're looking at a share of the column, it's going to be about, because it's a bigger component of the overall bill.
So I'm sorry, I'm not sure I'm following your math. We're looking at the $4.18. Is that right?
Correct.
And you're saying that's half of what amount?
That is half of the PCAM amount, which itself is half. So it's about a quarter.
Okay. And just to briefly step back into this PCAM, the PCAM changes that we see in the bill impact analysis, does that include a reset of the PCAM base?
Yes, sir, it does.
And does resetting the PCAM base include QF costs for the record, that's qualifying facility costs?
It does, and that's a row that's included in there too.
Has any party disputed the recovery of QF costs in this proceeding?
I'm not aware of any, no, sir.
And then another change associated with the PCAM is this deferred rate. Is that correct?
Correct.
And that's set in other separate dockets from this one?
Yes, sir, that's correct. I think I've got that listed down under the box for the citation.
Okay, and this box with the yellow bar at the top that says residential bill impact dash table. Can you tell us exactly what it is you're trying to show in that box?
Well, this box essentially scales kind of the typical bills as the KWH or the usage level increases.
Okay, right. But let's just focus specifically on a typical bill using 750 kilowatt hours per cycle. You're showing a bill change of $12.60 or a percentage change of 13.81%.
Right.
What does that reflect?
That's just the non-PCAM related changes. So if you wanted just to isolate those changes, it corresponds with so if you look at the 750 and you look, there's a $12.60 bill change and a 13.81% change that corresponds with the prior two columns above. And you'll see over to the left in the shaded gray box, that's for 750 kilowatt hours. So a way of matching that above table down to the below table is just looking at that shaded line and comparing it to that blowout, essentially what's up there on the top.
Okay. And
so just to carry on a little bit further, we've done that same thing. I've done that same thing and carried it out to 1,000, 2,000, all the way up to 96,000 kilowatt hours.
Right. And just to be clear, when you say you're pulling out the PCAM changes, that would include both the base reset that's involved in this case and also the deferred rate from another case?
Yes, sir.
So are property tax changes reflected in this bill impact analysis?
Yes.
And do those amount to about $2.19 if you add the two row 18 to row 22 above?
Yes.
So if I were to subtract $2.19 from $12.60, would that give me an idea of the bill impact, excluding both PCAM changes and property tax changes?
Yes, sir, it would.
And subject to check, would that be $10.41?
Yes, sir, that sounds correct.
And if you calculate that proportionally, it's roughly just under 11.5%.
That sounds correct.
And are you aware that there's a statute in Montana that requires this commission to allow the tracking of property taxes?
Yes, sir, I'm aware of that.
I had crossed out some language in the exhibit, and I just, for the record, that had said subject to future refunds. The base PCAM adjustment in this case will not be subject necessarily itself to a future refund. Isn't that right?
That's correct. I think what that was supposed to mean is subject to reconciliation. We do have a PCAM reconciliation process. So in the future, we don't, I think there's some discussion earlier that I had with the commission. I don't know where those, or somebody else, I don't remember. I don't know where those will go in the future, but there will be a reconciliation on those.
Okay, thanks for clarifying that. Okay, with that, Mr. Chairman, I'd move for the admission of MCC 6.
Is there objection to admission of MCC 6?
Mr. President, I concur with MEIC's position on this exhibit.
I believe that MEIC withdrew its initial objection. So you're agreeing with the withdrawal of the objection?
No objection to the exhibit. I think it does help clarify, and I want to just make sure the record's clear with respect to all of the other issues that we've raised and gone over, I think.
So you're not objecting?
Correct. Thank you.
Thank you. Is there any objection to this document? Seeing none, MCC 6 is admitted. Mr. Brown.
Thank you. Could I have you briefly turn now to the stipulation or settlement on page 4, table 1? Were you here when Ms. Trinnell calculated that 93% of the increase is going to the residential and GS1 secondary classes?
Yes, I remember that.
And you understand how she got that percentage?
Yes, sir.
If I were to add the residential and GS1 secondary total revenues as they currently stand, as shown in that table in the blue column, as a percentage of the total electric revenues, subject to check, would you agree that they are currently approximately 87.7% of total revenues?
So would agree. Yes.
And if I were to add the residential and GS1 secondary total settlement revenues as a percentage of total electric revenues, would you agree, subject to check, that they will be 88.4%?
That sounds correct. Yeah.
So the change as a result of the settlement is to go from 87.7% of revenues to 88.4% of revenues?
That's correct.
Were you here? Well, of course you were here. Do you recall when Ms. Trinnell calculated the $150 million figure?
Yes, sir. I remember that.
Do you know whether that includes both electric and gas increases?
I don't know for each of them. I think there were some were electric only. As I recall.
Right, but do you know whether the 150 million total figure includes the gas increase here?
Yes.
It does.
Yeah.
And the prior rate cases that she compared that to, do you know whether they were electric, gas, or both electric and gas?
I think some were not. I think one was both, one was not.
Okay. Can I have you turn to the infamous paragraph 15, the settlement? Okay. And we've heard a few times in this hearing that there would be a prudence determination before any Yellowstone costs are included in rates. Do you recall that?
Yes, sir, I do.
Are you aware that in Montana, we have a state law that allows the utility to request interim rates?
Yes, sir, I'm familiar with that.
Is there anything in paragraph 15 that you see that would prohibit or preclude Northwestern from requesting interim rates in the peak when it comes in to reset the PCAM base?
There is nothing in there that would preclude that request.
And are interim rates, are they subject to refund?
They are.
So if we consider interim rates being a point where Yellowstone costs would be recovered from ratepayers, would you agree that it's possible that there could be Yellowstone costs recovered from ratepayers on an interim basis before there is a prudence determination?
There could be. And so, but it's important to keep in mind, as you noted before, that they are subject to refund. So if the commission comes back and has a adverse finding with regards to prudence, those dollars, at least it's my understanding, would roll back to customers as a refund. So technically, yeah, rates could go up a little before that prudence determination comes up through interim rates. But ultimately there's a check on that from the commission and there is a refund on that. So I think to be very clear about that, I still think the spirit of my answer earlier to Mr. Trinnell was accurate. And that is, I think at the bottom line, at the end of the day, there's not going to be a rate increase until the commission looks at the prudence of those.
Well, to be fair, Dr. Dismukes, there won't be a final rate increase.
That's the final rate increase, right?
Ms. Harbine asked you yesterday and a bit today about the allocation here in the stipulation. And I think you agreed that less could have been allocated to the residential class if your minimum increase or some minimum increase had been enforced across all rate classes. Do you recall that?
Yes, sir.
Can you give us a sense of the magnitude of how much the residential increase could have been reduced if there had been a minimum increase across all rate classes?
Yeah, It wouldn't have been, because those classes can tend to have smaller dollars overall, the amount that I could have reallocated on what would already be a small percent would not have been a huge amount to swing the needle a lot. It would have, and it would have lowered that. But, you know, again, in the settlement, there's always give and take on these issues. You know, in consideration of all ratepayer interests, not just residential ratepayers, but the larger industrial users and the other commercial users, you know, this was the outcome that we came to.
Okay, thank you. Sorry to jump around a little here, Mr. Chairman, but I briefly, just with respect to Yellowstone, the other thing that came up was that could result in another rate increase when that comes in. Do you remember that?
Yes, sir.
Discussion. Is it possible that when the PCAM base is reset after the Yellowstone plant is in service, that there could be a rate decrease?
There could be. It's indeterminate right now at this time because it requires some speculation about where markets are going to be, but it will be the case that the company will be able to avoid purchases that it makes in the market as a consequence of adding Yellowstone, assuming the commission finds it prudent. And if that occurs, there'll be an offset.
So are those the capacity contracts that we've heard referenced?
Yes, sir.
That would come out of the PCAM base at the time that Yellowstone is added?
That's correct. Or it could be capacity or any energy that's offset by the plant itself. It could be capacity, it could be other avoided energy, it could be other things.
Okay. This up here, Mr. Chairman. Yesterday, there was a question about whether MCC represents cooperative customers. Do you know whether the Montana Consumer Council represents customers of cooperative utilities?
It's my understanding they do not.
And there was also some discussion about rate shock for irrigators. Do you believe that the a little over 6% increase for irrigation customers will result in rate shock for those customers?
No, sir.
And in light of the entire record here and the allocation studies that were in the record and all the proposals that were on the table, do you believe the stipulation results in rate shock for any of the customer classes?
I heard a voice out there and couldn't hear what it was said, Mr. No.
Mr. Chairman, avoiding rate shock is one of the fundamental goals of rate allocation and rate design, and it's been asked about repeatedly in this hearing.
All right, I'll overrule. Please proceed.
No, I don't. And as I mentioned several times in my testimony, both in the written form and my oral testimony, by capping this at 1.2 times system average, that attempt has been made to keep any one class from receiving that kind of rate shock.
Do you know which rate class Walmart is in?
They are in the general service primary account, I believe. GS1 primary. Or secondary. I'm sorry, secondary. It's the first row.
Okay. And I believe that's in the transcript, Mr. Chairman, so I don't mean to testify.
Yeah, I assume that most of those stores are going to be in the secondary.
Okay.
Like any other retail store.
Okay, let's assume Walmart's in GS1 secondary. Do you know where all other grocery stores are in the state? Would they be in the same rate class?
Yes, if they're of comparable sizes and have similar loads, which most do.
Okay, so
refrigerating load, lighting, things like that.
So as far as you know, Walmart pays the same class rates as all other grocery stores in the state?
Assuming they're on that tariff, yes, sir.
I may just have a moment, Mr. Chair, to make sure that's everything. spread over a few days here.
Sure.
Okay, I think I just have one more question here for you, Dr. Dismukes, and that's because we've heard quite a bit about the impact on customers' bills of this increase. Can you just address briefly the issue of the customer charge and how that affects customers' bills?
Yeah, so there will be no increase in the customer charge, particularly, well, for any customer for residential customers. I think there were some other offsetting rate design changes that maybe some of the commercial customers negotiated. But for us, for residential customers, there were no changes in that. So if you're thinking about some kind of bill impacts and potential regressivity issues with smaller use customers, that cost of access will not change for them as a consequence of the stipulation in the settlement. And customers will be in charge of their bill in terms of the ability to avoid at least part of that increase if they adopt energy efficiency measures, conservation, things of that nature.
Do you have a sense of, well, I'll leave it there, Mr. Chairman. Thank you, Dr. Dismukes.
You're welcome.
What would you like to do with this witness?
Mr. Chair, I did agree to, now that parties have had the benefit of our foundation and our exchange, I would like an opportunity for redirect if we do this still, and have the last word, but I don't object to parties having, if they have additional cross for Dr. Dismukes about MCC 6, but I do intend to ask that Dr. Dismukes be permanently excused.
All right. Well, I think what the parties had sort of informally agreed to was to allow another round of cross-examination on MCC 6. So let's move forward with that. Ms. Trinnell.
Thanks, Mr. President. Dr. Dismukes, I'm looking at MCC 6. Who created this?
This was done at my office with my staff.
And okay. And when?
This is a variation of some analyses we've been doing over the last couple of weeks, week or two, concurrent with probably the tail end of the settlement process. I've cleaned up some of this for external use and put some citations in here. I think that is new from some of the stuff we did before, and provided some documentation as well. And that was done the last day or so.
Dr. Dismukes, I want to just clarify. I think you were explaining that of the 150 plus million increase here, about, I think we talked about 69 of that being attributable to the PCAM. Is that right?
Yes.
Okay. And I'm just trying to have the context to talk about this exhibit, because I think what you were saying is about, so can we call that 70 million?
Okay.
Okay. And so was it, as you were explaining this, was about half of that 70 million, and I'm trying to understand it, so correct me if I'm not saying this correctly, is about half of that 70 million power supply purchases? Was that what you were explaining?
Half of this typical bill analysis here is about supply related changes for electric customers,
which come from the PCAM. Is that right?
Correct.
Okay. Which is a 70 million.
Yes.
Okay. And I'm trying to understand what you said, because you were talking about, so if that's 70, and then you were talking about half of that 70 being, and that's where I wasn't quite sure I was following what you were saying half of that 70 is. I think you were saying half of that 70 is attributable to purchasing supply. And that's what I'm trying to clarify.
I think half of that was attributable to the deferral.
deferral. Okay. And did you say that there was a chunk of the PCAM that was purchased supply in 2021? Is that accurate?
I don't know. Let me back up. Relative to this exhibit,
Mhm.
the PCAM part of this, about half of it's for the update on the base, and the other half is associated with the deferral.
Okay. Dr. Dismukes, would you agree that 2021 was an anomalous year for the amount of power that Northwestern bought on the open market?
I don't have that number. I can't say.
Okay. And would you agree with me that when Montana customers open their bill and pay it, they don't have the PCAM broken out as a separate line item on their bill? Do you know that to be true?
I'm not familiar with how the bill's set up. I know some of the charges are broken out and functionalized from the old days, I think from restructuring, but I don't know if where that piece falls.
Okay, and they're not in Montana, so.
Agree, subject to check.
Thank you. Thank you, Mr. President.
Thank you, Ms. Trinnell. Mr. McGraw.
Thank you. Well, just very briefly following up on Ms. Trinnell's line of questioning, isn't it fair to say that customers, when they open their utility bill, look at the total of the bill?
Yes, sir. I believe
They're not looking at the various items, line items in the bill, the component parts.
I don't know that I would agree with that, but
Really?
people pay bills.
Really, right. So first and foremost, so they look at the total. Is that fair?
They look at the totals, but it's my experience in interacting with consumers that they often are perplexed by the large number of items and credits and taxes. So I don't know. And I agree that they don't care about the individual lines.
I totally agree that they're confused. And that total includes the PCAM assigned costs, correct?
Yes, sir. You're right. Yeah.
Thank you. No further questions.
Mr. Rita. Noble Northwest.
No questions. Thank you.
Amy Icy.
No further questions. Thank you.
Okay, commissioners. Line of questioning related to this document, MCC 6. Vice President Fielder.
I don't have any questions at this time, Mr. President. Thank you.
Commissioner Pinochi.
Thank you, Mr. President. I want to follow up on Mr. Brown asked about these stores.
Commissioner Pinochi, is this directly related to MCC 6?
Mr. Brown can ask the questions about the rates that these Walmarts might have. I think I should be able to follow.
Out of courtesy and deference to my colleague, please proceed.
A smaller store in a rural area. I have 22 counties I represent. My knowledge, only 2 have Walmarts. A much smaller store would have a different rate because they don't use as much electricity as Walmart. Is that true?
If they're demand or energy related, they may have a different overall average rate, but they're still taking service from the same tariff. How that works out on average is really a function of load and not price discrimination on the type of customer itself.
A smaller store will meet a smaller load, which means they don't get the same rate. Is that correct?
They, again, I don't think that's technically accurate. They get the same rates that are listed on the tariff. Now, whether on average that number is higher or lower really depends on the load for the store. If the other things equal, they're smaller than a larger load that can spread over some of those demand costs over the larger load, then yes, I would agree. Probably the larger load is going to have a lower average effective rate when you take the total dollars and you divide it through with the load, but they're still taking service off the same tariff.
This is the largest rate increase I've ever seen. We heard testimony today at 28%. How can you say there won't be a rate shock to a retired person on a fixed income facing a 28% increase in the bill?
So the context of that discussion was relative to the settlement-based revenues. And I think in me and Mr. Brown's discourse, I think it was relative to the irrigation customers. And again, that rate shock was in the context of what we did to assure that no one class got a higher than proportional increase and essentially shock from that increase. And when we looked at those, I had those rules that we discussed earlier between assuring that they didn't get too significantly above the system average, which was 1.2. And so by definition, that number is far below that overall threshold. So it didn't exceed it from a rate shock perspective.
The question on irrigators at 6.5%, I'll agree may not be a rate shock, but he then asked about the residential customer. I want to be clear, you don't think there's a rate shock for the residential customer?
It has not been my testimony here today that these aren't large increases. But relative to rate shock, as we've used it in terms of allocating the revenue responsibility that was agreed to in the settlement, no one class has gotten a disproportionate increase relative to those rules that would constitute that shock outside of the standard measure that we used relative to their cost.
Thank you, Mr. President. I just wanted to follow up on Mr. Brown asked.
Thank you, Commissioner Pinochi. Commissioner Bukacek.
Very briefly, so what you're giving is an objective measure of rate shock as opposed to subjective or emotional reaction to a bill. Is that correct?
Yes, ma'am.
Thank you. No further question.
All right, I don't have any questions for this witness at this time. Mr. Hamilton?
No questions.
Okay. Let's do limited recross. Ms. Tranel. Mr. Uda. Newell Northwest. NWE. All right, so redirect.
No questions, Mr. Chairman. Thank you.
Okay, I think you requested that this witness be permanently excused. Do I recall that?
Yes.
Is there any objection to Mr. Dismukes being permanently excused? Seeing none, Mr. Dismukes, thank you for coming today. I appreciate your time. You are permanently excused. Safe travels home.
Thank you.
Okay, Mr. Brown.
We have one more settlement witness. So, I mean, if Mr. Brown would like to call his next witness.
No,
That wasn't
happy
the
to have-
plan. That wasn't the plan, to be fair.
happy to have this conversation offline, Mr. Chairman, but I guess I was expecting after the settlement witnesses finished up, we would go through the rest of Northwestern's witnesses before then going back to intervener witnesses.
Okay.
That is our understanding also.
All right.
So Dr. Dismukes is. I do have just one procedural issue, small, before we call Ms. Fang. If you want to get started with her before lunch, she might take an early lunch if that's your preference. I'd like to make a motion to strike. There were some gratuitous comments made by 350's counsel related to the MCC and their motives and the job they did. And I just, in my view, it should not be part of the record. It violates our rules of decorum and the professional rules of responsibility that you had cited to us. So I think they should be stricken.
Can you point to specific comments?
When Mr. Brown objected to a question from 350's counsel that would have elicited information subject to Rule 408, she added a comment. You overruled her or you sustained Mr. Brown's objection, and she added a comment for the record that the MCC, she wanted the record to reflect that the MCC was trying to withhold information and evidence that they did or did not do their job. And I just felt it unfairly impugned the MCC, who I don't always agree with the MCC, but I think that is wholly unfair.
Mr. Brown, do you want to weigh in on this? I mean, the comment was directed at you and not Northwestern Energy.
I have a thick skin, Mr. Chairman.
All right, I appreciate your graciousness, Mr. Brown. I'm going to deny that request at this point in time, but I think the point needs to be reiterated. We have a emotional case before us, correct? A lot of public interest. We have a number of parties participating in this proceeding at a level that is most unusual, regardless of whether this is an administrative proceeding or a court proceeding. The parties have been very cordial and amenable to each other up to this point of the hearing, and I would ask that we reset that back to where we were prior to the colloquy that everybody had about 30 minutes ago. All right, are we in agreement with that?
Yes, Mr. Chair.
We have processes in place under Montana law that allow the parties to try to address any deficiencies that they think have incurred in this process. We are at the time and place that was set forth for this hearing under a scheduling order that was set for September of 2022. We are going to move forward with that process, allow it to play itself out. We will provide opportunity for post-hearing briefing for the parties. And then you can decide what you want to do from that, but we are going to complete this hearing in a time frame that is timely and that doesn't stretch the commission's very, very limited resources. Okay. That's probably a good place to break so that we can all have lunch. All right. So just to clarify, Ms. Heim, where would you like to go once we come back with lunch?
We will recall Cynthia Fang to do her live direct and then cross-examine and commissioner questions and redirect.
Okay.
I'm sorry, on the settlement only.
Okay. So everybody knows where we're going to pick up. After lunch, the time is now 11:36 a.m. I'm going to give you an extended lunch today so everybody can reset, come back prepared at 1 o'clock. We'll resume the hearing. Again, time is 11:36 a.m. We will go off the record.